𝘰𝘂𝘴𝘪𝘐 belongs to Guyana.
In particular, on the issues relating to Venezuela's recent referendum. Our Honorable Attorney General, Madam Registrar of Deeds, Registrar of Commerce, Deputy Solicitor General, Senior Counsel, distinguished ladies and gentlemen, good afternoon. The issue concerning the arbitral award of the 3rd of October 1899 is perhaps one of the most significant legal issues of our time. Guyana's response to Venezuela's increasing aggression, including its recent decision to hold a referendum which seeks to validate unfortunate intentions. The legal aspects of that is our main defense. While we are quite fond of the Guyana Defense Force, we are not expecting to resolve the issue by armed conflict. Speaking for myself, I'm a little bit probably too old to make it to the front lines. Apart from the legal issues, of course, we recognize the efforts of the government in increasing awareness in the communities by holding events across the country. We are very pleased that the Attorney General has been kind enough to join us this afternoon to discuss the specific legal challenges. While the referendum may have passed in history, the consequences of it continue to live on. I know that you're not here to watch me bat, but rather the distinguished lady and gentleman to my right. But I would like to say that on behalf of the bar, we recognize the leadership that the government, especially the Honorable Attorney General, has shown in ensuring that Guyana's case is presented adequately in the International Court of Justice. As I remarked recently at our annual dinner, if you have not yet had the opportunity of looking at the presentation by our advocates, I would strongly urge you to do so. It's a masterclass in history and advocacy. I think this is one occasion when a lawyer sends the bill to the AG and it's paid almost immediately, without hesitation. Worth every cent. Our speakers this afternoon are well known. For the benefit of those joining us remotely who may be unfamiliar with them, I would like to introduce our first speaker. Dr. 𝘔𝘁𝘪𝘠 is a friend and colleague. She's a lecturer at the University of Guyana, and she has participated in symposia such as this on several occasions, and her observations on behalf of practicing lawyers has been well received. We're pleased that she's able to join us, and I'd like to invite her to make her presentation. Thank you.
Thank you very much, Mr. Burt-Smith. Honorable members of the head table, Attorney General, and my senior, Mr. Ramcharan, distinguished colleagues, Senior Registrar of Deeds, colleagues, students, good afternoon. I'm hoping that we could have a very interactive session this afternoon. I'm going to be brief, but I can tell you there is a strong likelihood that the other members of the head table would not be brief. However, I want us, as we examine this case, this matter, this controversy this afternoon, that we bear in mind two very trite, what we would call trite law, two very basic legal principles. One, he who alleges must prove. And secondly, when you raise fraud, you must be able to plead it and prove it. And I believe that the conduct we see coming from our neighbor really relates to those two issues. Because at every formal engagement, they are unable to prove their allegations. So let us start off with the fact that they are contending that the 1899 arbitral award is null, it's void. It really resulted as a result of a collusion as a result of fraud between the president and judges sitting on that arbitration. So that's their allegation. And since about 1962 to now, they have been alleging this. A lot of the allegations take place outside of formal settings. Whenever there is an engagement, because I want us to look at a few things. Every time they have had to prove it in a formal setting, there is a difficulty. There is a difficulty because, one, they're relying on a memorandum which was written by junior counsel who was representing Venezuela at the arbitration, that, you know, he wrote this memorandum and he said that it should be opened only on his death. So there are a number of difficulties there because he's deceased. The persons who sat on the arbitration, by now they're deceased. There's a difficulty there of proof. And as lawyers, we know, as I said, how we have to prove fraud. So it was really no surprise that this matter couldn't be resolved by the commission. So the first step, after these allegations, and Guyana was about to be birthed as a brand new nation, it was necessary, at least it was believed that it was necessary, that we enter into that 1966 Geneva Agreement. But certain protocols and procedures were put in place for this matter to be addressed in a peaceful, amicable setting. But again, you have to prove these allegations. Our neighbor was unable to do so. And I believe at every stage of that process, the good office process, they have been unable to do so. And so we fast forward now to a situation where Guyana, after the direction of the Secretary General of the United Nations, filed its suit before the ICJ. And we see this same conduct continue. We see this trend continue where in the formal, at the court, the formal setting, where you should, you are saying that there was this gross collusion, this fraud which occurred. This is your chance to show the world what took place. But again, we see a failure on the part of our neighbor to properly present their case. I agree with Mr. Bert Smith about the masterclass presentation, which we saw coming from our advocates. And this is because at every stage, as we examine this matter, at every stage, the Cooperative Republic of Guyana, we have utilized the legal mechanisms, we have utilized the organs of the United Nations, we have complied with the Geneva Agreement. When you look at that agreement, the agreement speaks, first of all, to establishing the commission, but it doesn't stop there. The agreement goes on to identify the procedure which should be adopted if the matter was not resolved at the stage of the commission. So when that failed, what did Guyana do? Go and brawl in the streets and put on uniform and run around? No. We again utilize the procedure which was outlined by Article 2. Article 2 sets out the appointment of the mixed commission. Then Article 4 then goes on to talk about the procedure which must be followed if there's a failure on the part of the mixed commission to arrive at a full agreement. Article 4 goes on to identify the fact that the states should utilize Article 33 of the Charter of the United Nations to resolve this matter. Guyana has done that. Guyana has complied with the Geneva Agreement. The matter is before the ICJ, and while the matter is being engaged at the stage of the ICJ, what does our neighbor do? Hold a referendum, a consultative referendum to empower the government to, according to question 5, to annex our Essequibo. When you examine, let us go back to the 2 principles of law. Most times, we see this even from humans. If you can't prove your case in court, some persons resort to bullyism. And I believe it's the inability on the part of our neighbor to establish their case in court. That is the reason why they may have resorted to this consultative referendum, which we have seen. As to their plans after this, I still have a strong belief that this matter could be resolved through diplomacy. I still believe so. I believe that the international bodies, the countries who have weight, CARICOM, they must all put pressure on the leadership of the country. Pressure needs to be placed on the leadership of the country because states have an obligation to comply with the principles of international law. And what we see happening here is a state going on a frolic of its own. And there are dire consequences to that. The ICJ issued its order recently. And I was sharing lightly with AG and Senior the interpretation of that decision by our neighbor. I was shocked when I saw it. President Maduro said he won. Anybody saw that? President Maduro said he won, that justice, the Venezuelan people received justice. He said Guyana's entire case was dismissed. What do we do? I believe the time has reached because we cannot wait. I don't think the world should wait until there is another invasion, there's another illegal occupation by another bully. We have seen bullies operating around the globe, and this should not be taken lightly. And so there has to be pressure. I believe pressure has to be put, and it has to be put on the leadership now. It has to be done now before any illegal act is taken. Because if you could look at that decision and decide that you won from that decision, right, that you won, I mean, this is bullyism at another level. And so I really believe still, I'm hoping that Guyana would not have to resort to military force. Like Ronald, it's a little difficult for me now to join. I mean, we're getting up there. So I really hope we don't have to go there. But what I do know is that most Guyanese, we are patriotic, we love this country, and we will not step back. This is not a time we could allow fear to take a hold of us. This is not a time that we should lie down. We cannot. We have complied with the law. We've acted within the law. We have utilized every possible avenue and procedure we could utilize on the Geneva Agreement. And so, if, and I hope not, Maduro steps out, we will have to step back, Pauline. We're gonna got to step out too, if it comes to that. But as I said, I strongly believe that this matter can still be resolved at the diplomatic. I see 𝘂𝘀𝘴𝘪𝘐 shaking his head. He doesn't believe so, right? But it calls, I believe it really, really calls a pressure to be placed on the Venezuelan government and the Venezuelan people, because this, what we are seeing here, has happened in other places on the globe. We cannot sit with our hands folded and, allow something like this to happen to us. All right? So I'll await the questions, and I will hand over now to Senior to give his own view. Well, to Ronald.
Thank you very much, Dr. Kite. I think we can take questions that you may have for the very end of the session. Our next speaker, Mr. Ralph Ramkran, Senior Counsel, really requires no introduction. Mr. Ramkran is the principal partner of the firm of Cameron and Shepherd, Guyana's oldest law firm. He isn't paying me, so I'm not going to say anything more about his firm. Most of us are familiar with Mr. Ramkran's writing in currently on his blog, Conversation Tree, which I look forward to every Sunday. I've learned quite a bit from it. Many of you may not know that for quite a number of years, Mr. Ramkran was Guyana's representative in part of the process being administered by the Secretary General of the United Nations. And so his experience in this subject matter is firsthand, straight from the battlefront. So without further ado, Senior Counsel, the mic is yours.
Mr. President, Mr. Attorney General, Dr. Kite, distinguished colleagues, Mr. Fraser, Mr. Fongafat, Registrar, I'm very pleased to see such a large turnout of lawyers for an event where no drinks are involved or no fun or frolic. It's unusual, but the circumstances that Guyana faces are not unusual. And one of the reasons why we are not so frantic about the 𝘔𝘶𝘴𝘪𝘐 region is that we live there. We own it, we reside in it. 𝘔𝘶𝘴𝘪𝘐 is just across the river, and even before the river. So it's not an alien part of our territory. And we believe, because we have always known 𝘔𝘶𝘴𝘪𝘐 to be part of Guyana, that nothing really seriously can happen to 𝘔𝘶𝘴𝘪𝘐. I mean, how can you conceive that 𝘔𝘶𝘴𝘪𝘐 is going to be taken away from us? And that is one reason why we're not so, we do not appear to be so worried. Another reason is it's not taught in our schools, like in Venezuela. In the schools, children are taught about 𝘔𝘶𝘴𝘪𝘐. In Guyana, that doesn't happen. I believe that some effort is going to be made to introduce the issue of Essequibo in our schools, and that would be very useful. This problem between Guyana and Essequibo started a long time ago. I'm not going to go through the history, so you don't have to be afraid of that. But both the Dutch and the Spanish began to colonize the South American region in the 16th century, the Dutch in the latter part and the Spanish during the course of the 16th century. And that's the origin of this problem, colonialism. You know, in Africa, colonialism created boundaries that had no reference to geographical or ethnic occupation. They just drew lines where they conquered. And countries in Africa has determined that they will not allow border problems. In other words, they will accept the boundaries that colonialism left. In the Middle East, the same thing happened. And once again, in the Middle East, there were arbitrary boundaries. They remained as they were under colonialist and imperialist mandates. In Guyana, our story really starts in about 1830, because several countries, it was called Gran Colombia, fought the Spanish, and they succeeded in gaining their independence. Gran Colombia comprises several countries. The large ones were Venezuela, Colombia, Panama, and a few others. And in 1830, Venezuela left the Gran Colombia body and declared itself independent, and its independence was recognized in 1835 by Spain. The counties of Essequibo, Demerara, and Berbice were united in 1831. So Guyana and Venezuela kind of started at the same time as two whole countries. Venezuela independent, British Guyana a colony. So when the British took over in 1831, they decided that they needed to identify the boundary. What had happened is, between the Orinoco and the Essequibo, the Spanish never came beyond the Orinoco. They made some attempts, and they were driven back by the Dutch, who were already occupying in the latter part of the 16th century. They were driven back by the Dutch. So they established their major area of the major fort, the major settlement, in a place called Santo Tome on the eastern bank of the Orinoco River. And they never came beyond that. So the British decided, the first thing was that the Royal Geographical Society contracted a man named Robert Schomburgk, a German, who was a botanist, he was an explorer, he was a surveyor, he was many things, to look at the boundary and demarcate the boundary. And the British in 1840 contracted him to demarcate the boundary, which he did. And when the British showed that to the Venezuelans, they rejected it out of hand and claimed up to the Essequibo River. And that's when the story started with Schomburgk. Nothing happened after that. And in 1860, Venezuela suggested an arbitration. 1863, Venezuela suggested an arbitration, and the British did not agree. And in 1887, Venezuela broke diplomatic relations with Great Britain because of this issue. And shortly after, in 1894, the United States took up the matter. Cleveland was then President of the United States. And the Americans started to communicate with the British, threatening them and raising the issue of the Monroe Doctrine and claiming that the Britain cannot colonize any region in South America because of the Monroe Doctrine. Britain defended itself. It said it was not colonizing anywhere. It was already there in British Guyana, and all it was trying to do was to demarcate the boundary. But the US president persisted, and eventually the British agreed to arbitration. The arbitration was signed, was the Treaty of Arbitration. It's sometimes referred to as the Treaty of Washington, was signed in 1897. And as a result of that treaty, the arbitration panel was appointed. There were two British, these were the British judges. Four of them were two British, two American. The Americans represented Venezuela. The Americans have been the people who were pressing the Venezuelan case. So the Americans were nominated by Venezuela. There were two Supreme Court judges. One was president of the court, and the British were two British judges. One was Chief Justice, and one was president of the Court of Appeal. So, and they chose a man named Martins, Theodore Martins, as their president, unanimously. Martins was an expert in arbitration. He was an academic. He was a professor. He was Russian. He was not actually Russian. He was from the Baltic states, but the Baltic states were then, I think, part of Russia. So he was Russian. So we always need to look at the Russian vote in the ICJ, because the Russians, we understand, don't want to vote against a man who he was a very, very distinguished scholar, a man who had Russian lineage. So the arbitration tribunal met, and they issued the award, a unanimous award, on the 3rd of October, 1899. The boundary was demarcated, and Venezuela accepted it. I will go into a little bit more detail later on. And then the next thing that happened is in 1962, at the United Nations, Venezuela rejected the arbitral award. To resolve the matter, the then government, the PPP was then in office, agreed for an examination of the documents in the British archives to see if they find anything that suggested other than honesty. They were at the time talking about a man named 𝘱𝘁𝘀𝘍𝑜. They made several kinds of arguments, but the one that stuck, the one that grabbed the public attention was this junior lawyer who had received a national award from Venezuela. And soon after he received the national award, he wrote this memorandum, which he said must not be opened until after he died. And the memorandum said that this thing was a deal. It was a deal between the British and the Russians. Well, it was a deal. It was a compromise. The border issue was a compromise between the arbitration panel. That's well known. So after the 𝘱𝘁𝘀𝘍𝑜 case was so weak, he left. They couldn't produce the original memorandum. It was eventually discarded at that point. Well, in 1964, the Geneva Agreement was signed. In 1966, the Geneva Agreement was signed. And the Mixed Commission met from 1966. The Article 1 of the Geneva Agreement provided for the Mixed Commission to meet for 4 years. The Mixed Commission met for the 4 years. Nothing happened. Then in 1970, the Mixed Commission met from 66 to 70. In 1970, the Port of Spain Protocol was signed, freezing Article 4 of the Geneva Agreement for 12 years. But it required discussion between the parties towards the end of settling the dispute. But between 70 and 82, we don't know what happened. The record is very bare. It suspended Article 4, which provided for the means of settlement if the mixed commission did not come to an agreement. In 1982, the Port of Spain Protocol ended. And in 1980, sometime during the presidency of Desmond Hoyt, discussions took place between Guyana and Venezuela, and it was agreed that they would ask the United Nations to use its good offices to try and resolve the matter. And that is how we had the good officer process, which started in near to 1990. Dr. Barton Scotland was the first good officer, and I took over in 1994. And the good officer process lasted until about 2010, when the last good officer died by accident, and nothing was resumed. Activity was still going on, but I was not, close to 2010, I was not deeply engaged with the process because it had not been very active, though there was some discussion going on. In 2015, its activity resumed, and in 2015, the new government came to office, APNO-AFC government, and I was re-engaged with the process at the request of the government in 2015. And in 2016 to 2018, we had written to the UN, the United Nations, asking for reference to the ICJ, International Commission of Jurists. So we began to pursue, the government began to pursue that, the new government began to pursue that, and the Secretary General imposed really, or selected, an enhanced mediation process, where he appointed a mediator from Norway. That process went on for those 2 years, and it was a very, very intense process towards the end, during 2018. And it didn't work out. So we then, once again, repeated that request to the UN Secretary General to refer the matter to the Secretary General, to the ICJ, which he did. So the matter is currently before the ICJ. Now, all the documents that I have referred to, the Treaty of Arbitration of 1897, the appointment of the commission, the arbitral award, the Geneva Agreement, the Port of Spain Protocol, and other related documents are all online. You can get all of them online. As a matter of fact, I didn't walk with my copy of the Geneva Agreement to office today, and I didn't expect to return home. I did actually. So what did I do? I printed a copy so that I can be able to prepare what I have to do. So you can get all of these documents online. So there is no reason, as lawyers who are presumably computer literate, there's no reason for you not to have these documents. And these documents are all very, very short. The Geneva Agreement is 4 pages. The arbitration decision is about 2 pages. The Treaty of Washington is 2 or 3 pages. All these documents are very short for you to be able to read. We have presented our memorial to the ICJ, as we are required to do, as we brought the case. And that memorial is also online, so you can read that if you want. And out of that memorial, I took out some portions in order to tell you, as lawyers you would appreciate. For example, the 1899 award is final and binding, and it was intended to be. That's one of our arguments. Guyana has submitted to the ICJ that where disputing parties have consented to arbitration, the resulting awards are binding on them as a matter of international law. I think you will understand that as a matter of municipal law as well. The principle goes as far back as Grotius. In more modern times, in 1874, Professor Goldsmith of the Institut de Droit International on International Arbitration said that arbitral awards are already well recognized in modern law. Recognition of the finality and binding nature of arbitral awards were made in 1899 in the First Hague Peace Conference, later in 1899 and 1907 in the Hague Convention for those years. In the 1990 case of Orinoco Steamship Company, United States against Venezuela, which was an arbitral award in several regional conventions, and in 1991, the Permanent Court of Arbitration confirmed the principle. There are many, many statements, cases which recognize the finality of arbitral awards. The 1997 treaty was a treaty of arbitration that the 1897 treaty was a treaty of arbitration that is to be interpreted in accordance with the general rules of international law governing the interpretation of treaties. Its terms unequivocally demonstrate consent and desire for the 1899 award to be final and binding. It states, the high contracting parties engaged to consider the result of the proceeds of the Tribunal of Arbitration as a full, perfect, and final settlement of all the questions referred to the arbitrators. So I don't think I need to explain the meaning of those words, but Venezuela, by accepting the Treaty of Arbitration, confirmed its desire for the border dispute to be finally settled by arbitration. Immediately after the delivery of the unanimous 1899 award, Venezuela acknowledged its final and binding character. 4 days after the award, its Minister of Foreign Affairs, its minister in London, its ambassador, declared, greatly indeed did justice shine forth in spite of all in determining of the outcome of the frontier, the exclusive dominion of the Orinoco was granted to us, which is the principle in which we set ourselves to obtain through arbitration. Throughout this issue, you will find popping up again and again Venezuela's desire for the mouth of the Orinoco, which they got. They full well knew that they had no presence east of the Orinoco, west of the Orinoco, east. They had no presence east of between the Orinoco and the Essequibo River. So what they were hoping for at all times was to gain the mouth of the Orinoco, which they did. Throughout the years after the treaty, up to the 1940s, Venezuela showed acceptance of the arbitral award. And in 1905, a mixed commission, once again, not to be confused with the Geneva Mixed Commission, a mixed commission was appointed to demarcate the boundary in accordance with the arbitral award. That mixed commission demarcated the boundary to the agreement of everyone, and the map was signed by everybody. So in 1941, the Venezuelan Minister of Foreign Affairs described the boundary as chose juge, which is settled. So up to 1941, Venezuela is on record officially as accepting the decision of the arbitral tribunal. Now, I mentioned about 1962, when the Venezuelans raised the matter in the United Nations and declared that they do not accept the 1899 award, and 1966. But what does the Geneva Agreement say? And why is it so important? And what are the lies that Venezuela has been perpetrating about this agreement. We don't know what were the circumstances which brought about the signing of this agreement. The diplomatic history of that era is not known to us. But the agreement was signed by Britain and Venezuela and countersigned by Guyana. But what we can say is that the preamble states that closer cooperation between Guyana and Venezuela could bring benefit to both countries, that any outstanding controversy would prejudice such cooperation and should therefore be amicably resolved. Now, the Geneva Agreement did not make reference to did not recognize the existence of a dispute about the border between Venezuela and Guyana. What Article 1 provides is that a mixed commission must seek satisfactory solutions for the practical settlement of the controversy which has arisen as a result of Venezuelan contention that the arbitral award is null and void. Now, the words satisfactory solutions for the practical settlement of the controversy have been lifted out of the Geneva Agreement by Venezuela and has been plastered all over the world in every discussion, in every meeting, and says that that is the objective of the Geneva Agreement for discussion leading to satisfactory solutions for the practical settlement. And the hint behind all of that, practical settlement is Guyana must give up some land. Practical settlement means something in practice, give up a piece of land. So, but if you read the Geneva Agreement, and though it's 4 pages, every time those of us who read it, we find something different. We find something we didn't think of before. Satisfactory solutions for the practical settlement of the controversy was the task of the Mixed Commission, and the life of the Mixed Commission was 4 years. So that function was spent by 1970. It is only the Mixed Commission who were required to seek satisfactory solutions for the practical settlement. After the Mixed Commission closed off, that was it. That function no longer existed. What existed was Article 4, which provided that, or the article after that, which provided that Article 33 of the United Nations Charter would apply if the Mixed Commission did not find a solution. So if those of you who you can check Article 33 of the UN Charter, it provides some mediation, discussion, negotiation, and a few other things, and it also provides for judicial solution. So what it required is that the parties must meet after the Mixed Commission ended and decide on one of these. And if they can't decide, the Secretary General must decide. And if that failed, they must meet again and decide on one of the other means. And if that didn't succeed, the Secretary General must decide on another means. So there are about 6 different means provided by that article. So that is what went down. We couldn't agree. The Mixed Commission failed. Good officer process failed. Enhanced mediation failed. And therefore, we asked for judicial settlement. And that is how that's how the Geneva Agreement framed it. And that is what we did. 2 things about the Geneva Agreement also. One is that Venezuela claims that the Geneva Agreement superseded the arbitral award. In other words, the Geneva Agreement implied that the arbitral award no longer exists. And the Geneva Agreement leaves the Essequibo region in limbo. Nobody owns it. Well, that's a lot of rubbish. All the Geneva Agreement provides is Article 4, which provides for the status quo at 1966 to be maintained. The status quo at 1966. That is what the Geneva Agreement provided. And those of you who read the decision recently would have seen the, not dissenting, but the separate decision of Justice Robinson of Jamaica. The court said that Guyana was in control of the Escobar region. Guyana had control of the Escobar region for the time being. Robinson is saying that the court should have said that Guyana has sovereignty over the Escobar region. And that is what the Geneva Agreement provided for. Now, I have to end now. My time is out, but I still have a lot of people here, but I think you'll get tired of me, and I need to give the Attorney General a chance. We have argued that the 1899 arbitral award enjoys a presumption of legal validity. These are international law principles, but all of you will recognize them as applicable in municipal law. The award enjoys the principle of legal validity. We have argued that the agreement was concluded, the agreement to provide for the Treaty of Arbitration was concluded with Venezuela having full knowledge of the relevant facts. We have argued that Venezuela's complaint that no Venezuelan was a member of the tribunal, that's one of the most recent complaints. No Venezuelan was a member of the tribunal. Well, it's not unusual because there's a case in the Pious Fund of the Californias, which involved Mexico in 1902. Mexico appointed 2 arbitrators from Holland, and there are many other cases in which the countries involved appointed other arbitrators. And Venezuela, America, the United States, was representing Venezuela. And that is why Venezuela, who presumably didn't have confidence in its own jurists, chose American jurists. Not only American jurists did they choose, they chose American lawyers. The lawyers of the four lawyers represented Venezuela. I don't remember who the 4th one, but there were 2 judges of the Supreme Court. There was 𝘍𝘀 and there was another judge, all American. So our argument is that for these reasons, the award was legal, valid, and binding. And I should end with this. Let me end with this. That the parties filed their argument, when the tribunal sat, the parties filed their printed arguments within the time allotted. Britain's argument comprised a single volume of 55 pages. Venezuela's argument comprised 2 volumes of 765 pages with 80 pages of supplementary material. 54 4-hour sessions were held and full arguments were presented by both sides. A full record of the proceedings were kept. The oral proceedings alone comprised 3,200 pages, oral proceedings alone. So one can conclude that the proceedings were thorough, exhaustive, and fair, and there were no restrictions on anyone. So there is no ground to conclude that this award was not valid. And the reason why Venezuela is now acting up is very simple, that they know they're going to lose. And that is why this behavior is occurring. Thank you.
Well, thank you very much, Mr. 𝘠𝘂𝘓𝘂. Ladies and gentlemen, we go from one general who has been to the front line several times to the Attorney General who has been to The Hague several times. And so without too much of a preamble, please welcome the Honorable Attorney General.
Thank you, Ronald. My distinguished colleagues from the head table, Senior Counsel, Mr. Stephen Fraser, Chief Parliamentary Counsel, Johnny Fongafat, Deputy Chief Parliamentary Counsel, Joanne Bond, Registrar of Deeds and Registrar of Commerce. I see councillors from the NDCs here, colleagues of the bar, members of staff, students. It's an honor to be afforded an opportunity to speak with you here this evening on this matter of national importance. And permit me to use this opportunity to thank the executives of the Guyana Bar Association for organizing this event. I made one telephone call to the president and I requested a forum of this type, and without any hesitation whatsoever, he agreed to organize it, and here we are. So you have heard a lot from the two presenters already, and it is not my intention to rehash what has already been said, but to re-emphasize that Venezuela's claim cannot be supported and is not supported by recorded history. It is not supported by international law. It is not supported by international diplomacy and the international legal process. The recorded history of our country and of South America vividly illustrates that Essequibo, the alleged disputed territory, was never under Spanish influence. Never. Those of us schooled in history would know that for the longest, for several centuries, more than a century, Essequibo was under the colonial control of the Dutch. Essequibo existed before Venezuela was born. As Mr. 𝘠𝘂𝘓𝘂 alluded to earlier, Venezuela, it used to be a strip of land called Gran Colombia, comprising of Colombia, what is now Venezuela, or parts of what is now Venezuela, and Panama. Essequibo was always there under Dutch control. Essequibo, the affairs of Essequibo used to be managed by the Dutch from the venue of Fort Island. That's where the court of policy was located in the 1500s, 1600s. Fort Caicoverall was there before Venezuela was birthed. Cayuni, Mazaruni are Dutch words, Dutch names. Leguan, Wekanam or Wakanam, Pomeroon. Those places predate Venezuela. And as a matter of history, we have not even dealt with the legal issues as yet. And then you come to the legal issue. Absolutely not a scintilla of evidence that can stand up in a court of municipal law, more so international law, has been produced to impugn, to invalidate, or to even shake the legal foundation of the arbitral award. None at all. if Venezuela is to get away with this gimmick, it will bring into question, or it will allow for dozens of international disputes similarly resolved, involving borders, involving many other international questions that have been resolved by arbitration and by conciliation, by mediation, and other peaceful method of resolving disputes. Countries can now reopen them on some flimsy allegation similar to what Venezuela is making. International law, the international legal process will never countenance Venezuela's contention and allow it to succeed. And I take great comfort in that fact. Stripped of all the esoteric and political rhetoric, what Venezuela claims is what is contained in that memorandum by this gentleman who requested that the memorandum only be opened after he dies. I've said elsewhere that this is one man, you know, they say dead men tell no tales. This is one man that got a serious story from the grave. And you can't question him. All of us are lawyers, or most of us are lawyers. You know, and as Ralph said correctly, the original document has never been produced. So it's some form of replication is what is relied upon as the first thing. Secondly, you can't question the maker of the statement. And you know in law that when that position obtains, the evidence is either inadmissible or at highest is of very little probative value. It has very little weight. How can that singular statement undermine and invalidate an arbitral award that was given birth through an agreement between two countries, witnessed by America, in Washington, Great Britain, and at that time it's called the United States of Venezuela. These countries signed an agreement that they will resolve this process through this arbitral award, and then signed the arbitration agreement. Venezuela now claims that no Venezuelan sat, but they nominated one of the American jurists. And look at the caliber of the people who sat in this tribunal. Britain asked Her Majesty's Privy Council to nominate the judges on its behalf. And the Privy Council at that time recommended the Chief Justice of England and the President of the Court of Appeal of England, two of the most powerful judicial officers in the British Empire. You have then on the other side, you have the Chief Justice of America and another distinguished judge of the Supreme Court of the United States. And the four of them agreed unanimously to appoint, at that time, a gentleman who was regarded as the foremost authority on international law and international mediation. That is the caliber of personages that this junior lawyer, Ralph was very kind, but when I read the records, he was fetching the briefcase. I mean, I did that job. I did that for many distinguished senior counsel, perhaps including Ralph. So I don't mean to demean the gentleman, but that was his role. So you have that statement coming from a person of that standing against a tribunal of the might that I have just explained. And the allegation is in the form that it is. And that's Venezuela's case. That is it. And I don't have to recite the fact that They acted upon it for 60 years without question. In fact, as they declared victory because it gave to them 350,000 square miles. They got from that award 4 times the size of what we know as Guyana. They got the entire Orinoco Basin and the land on either side, which was what they wanted. And Guyana got the land east of the Essequibo River. So that is why they hurriedly moved to demarcate the boundaries. And in the demarcation of the boundaries, they insisted on the letter and spirit of the award. They went to their parliament and they enacted those boundaries. They printed their maps and everything else. And the boundaries also demarcated our boundaries with Brazil, insofar as it intersects with Venezuela. I had the opportunity of looking at the actual record of the arbitration. Ralph described the mammoth nature of the record. I actually saw it. It's a whole filing cabinet of documents. The verbatim evidence, the exhibits, the legal submissions, the 2 sides, the case that they presented, and of course, the arbitration, the award itself. When I was AG the last time, it was in a filing cabinet in the Attorney General office that I discovered. I immediately called Carolyn Rodriguez, the Minister of Foreign Affairs, to tell her what I have. And she asked Ambassador Rudy Collins to come, and we went through the whole thing, and I tell them I don't want this document. These are 2 important documents to be kept at the Attorney General office. I believe a safer place is at the Foreign Affairs Ministry. And that's where those documents are. They have been reduced to another form for protection and preservation. So, when we approach the court, because of the nature of their case, Venezuela has not, first of all, they objected to jurisdiction, as you know, because they don't want this matter to be examined, because their case cannot withstand scrutiny. When the claim was first asserted in 1962 at the United Nations General Assembly, it came after Premier Dr. Cheddi Jagan wrote, the UN had just passed a resolution calling on all colonial powers to move towards self-determination and grant independence of colonial states. And Dr. Jagan capitalized on that opportunity and wrote to the UN requesting independence of British Guyana from Great Britain. And immediately they reacted. Venezuela reacted by lodging this outrageous claim. And then a process began. Dr. Jagan, they came and they met with Dr. Jagan, and Dr. Jagan said, well, go to the British archives and see if you have anything, bring back anything that can corroborate, I don't think Dr. Jagan used that word, to corroborate your case. And they went. There were other processes that the UN embarked upon between the British government's permanent representative at the UN, the US State Department, and Venezuela, They engaged in processes that lasted until 1966 to allow Venezuela to bring forth the information that it has, likely to impugn the validity of the award. And again, they abysmally failed to do so. I have examined also the antecedents to the 1966 Geneva Agreement, because strangely, Venezuela is relying on that very instrument. And they have the most injurious interpretation placed upon it. That agreement was negotiated between Guyana government played a very little role. It was largely a negotiation between Venezuela, the US, and the government of Great Britain. The negotiations were led by the permanent representative of the UK government at the United Nations General Council at the time, a gentleman by the name of Kroll, Chris Kroll, I think his name is. Yes, Mr. Kroll, I remember the name, Kroll. And it was made abundantly clear, several places, in several documents leading to the 1966 award, that this award was never intended to interfere with, undermine, or be a substitute for the arbitral award. That 1966 agreement was postulated upon the foundation that the arbitral award remains valid and binding on the parties and on the questions that it resolved. The only reason why the 1966 agreement was signed, Guyana wanted independence. It was signed on the 17th of February, 1966. We got independence on the 26th of May, 1966. It was felt, and perhaps for good reason, that it may be unsafe for Guyana to go into independence as a new state with this issue hovering over it, without there being in place a mechanism that would allow the parties, well, rather to allow Venezuela to ventilate this claim. And if possible, for the parties to work out some resolution, if that was possible. But it was to give Venezuela an opportunity to pursue a means other than a military reaction, which was quite possible and which was apprehended. And Venezuela, being the military might that it is, it was felt, and as I said, for good reasons, that this mechanism should be there that will allow for a peaceful process forward. And that is how the Geneva Agreement was outlined. And that's how it was formulated. That's why when they challenged the jurisdiction of the court, quite apart from Venezuela being a member of the United Nations, and by that membership itself confers the court with jurisdiction over all the members, because the court is the principal judicial organ of the United Nations General Assembly. The agreement itself is what authorized the Secretary General, if the processes outlined by Mr. 𝘔𝘶𝘴𝘪𝘐 fail, it is the agreement itself signed by Venezuela that authorized the UN Secretary General to recommend another means. And the UN Secretary General recommended the judicial option. How can Venezuela participate in all the processes and then empowers the UN, when those processes fail, to authorize another process, and when that authorization is made, you come now and complain that the court has no jurisdiction over you. So the court had no difficulty in rejecting Venezuela's plea of non-jurisdiction. And then before the court, again, rather than file a counter memorial, which is, in our terms, their defense to our claim, they constructed another ingenious argument to say that the case can't proceed because the UK is not before the court. That was their second procedural objection. Because UK, they claim, was part of the arbitral award. And if the court is going to deal with the arbitral award, then the UK should be there. Now, we are lawyers. We confront foolish arguments every day. The independence process of Guyana replaces the UK with Guyana. That by operation of law and constitutional process. Guyana stands in the shoes of the United Kingdom. So we had to explain to the court and give all our independence instrument, our constitutional instrument, our Republican status instruments, everything to the court to show that there is a smooth transition of parties. And United Kingdom is not a relevant party in the process. So that argument was overruled. And despite, so up to now they have not filed their counter memorial. The reason is that it is difficult, as you all know, to put that thing down on paper and maintain your dignity as an international lawyer or as a lawyer of any standing. So what they have done, resorted to political rhetoric and exciting patriotic sentiments. Some wise man once said that patriotism is the last refuge of the scoundrel. So that's what they have been doing. Rather than deal with the legal issues, they have gone into this euphoric fervor of exciting nationalistic and patriotic sentiments. So the distinguished Vice President of Venezuela went to the court and delivered a verbal abuse that lasted for nearly 60 minutes. That's what it was. At this last hearing, Venezuela assembled a very formidable lineup of internationally recognized and decorated scholars. 28 of them I counted. 18 or 19 of them are professors with PhDs in law and so on. None of the distinguished ones, or the more distinguished ones, presented. I don't want to disrespect the gentleman who presented, but all their firepower sat throughout that case. And that, to me, sends a signal. Those lawyers were not prepared to stand and speak after what the Vice President had planned to say, because they would have known that before. You have to submit your statements before the hearing. We all got the statements before. And I believe that they made a conscious decision not to speak at that hearing. Notwithstanding all of that, and driven and overwhelmed by defiance they proceeded to formulate that question, or those questions for the referendum, knowing full well that they are before the court. They're asking the people of Venezuela now to vote on whether the court has jurisdiction over them, when the court has pronounced that it has jurisdiction over them since 2020. And the two other even more bizarre questions about converting Essequibo into a state of Venezuela and converting the citizens of Essequibo into Venezuelan citizens, and then the annexure of the physical territory itself. Outrageous questions. And they got the judiciary of Venezuela to legitimize those questions. And then, so we knew that it would have been an uphill task to stop the referendum from taking place. We know that. But we are lawyers. You know that you ask for more rather than less. So we did ask for the court to prevent to prohibit the referendum from taking place in its current structure. We did ask that. But the underlying question, the more fundamental relief or measure that we asked for, was for there to be no actions taken based upon the referendum. And that is what we got. And that is what we wanted. The status quo order. President Maduro interprets those measures as a victory. Well, all of you will know that I had a particular nemesis for many years. Every time the court rules, either for or against him, he wins. And it is God's own duty now to go to the press to explain what I believe the court ruled. So, Maduro's interpretation of the order or the measures are very much akin to that type of thing. The referendum has been completed, and Maduro's government has disclosed that 10.5 million people voted. Statistics that are being seriously questioned and criticized by independent observers and analysts. In fact, Maduro's government has been accused by the international media of manufacturing those figures. If those votes, I read one analysis that says that if those votes are correct, it is more votes than the very popular Hugo Chavez got at his last election. That's the analysis of 10.5 million votes. Go on the internet and you will see yesterday there are pictures right across Venezuela of the polling stations, and they were empty. They were empty. I thought these things only happen in Guyana, but apparently it's contagious. So where did the 10.5 million votes come from? In any event, it's 10.5 out of a voting population of about 20 million, so it's only 50% if you go by those figures. The point I am making is that this gimmick of a referendum backfired. It backfired. It is back against the wall now Maduro triumphantly says, recently, a couple hours ago, that now that the people of Venezuela have voted on the referendum and the certificate has been issued, he will move to the 6th step, or the 6th stage. That's his latest pronouncement earlier today. What is that 6th stage? Is anyone's guess? Is it that he will violate the measure or measures imposed by the International Court of Justice? We have to wait and see. The International Court of Justice, however, in its ruling, I believe, emphasized two issues repeatedly, and I believe that they were deliberately done. One, it said on repeated occasions that the court has jurisdiction in this matter, and that Venezuela is before this court in this matter. And the second important point is that it repeatedly said that this decision or its ruling is binding on Venezuela, on the parties. As you know, we don't have the military might of Venezuela, but our army is committed and it is ready to move. We have secured the support of allies across the region and across the hemisphere. It is my considered view that, having regard to the historical role that the US has played in this matter, and to some extent the British government, they cannot be officious bystander. They cannot be in the position of the ordinary states on this issue. They have a duty, in my humble view, to ensure that a process that they engineered and participated in is respected. I don't believe that the international community will allow the ICJ's order to be ignored. If that happens, it will strike at the very foundation of the international legal process. It will strike at the foundation of global legal order. It will strike at the heart of the United Nations itself. The court is its organs. I have prepared some notes on how the ICJ orders are enforced, which I want to share with you. Judgments delivered by the court in disputes between states are binding upon the parties concerned. Article 94 of the United Nations Charter provides, and I quote, "Each member of the United Nations undertakes to comply with decisions of the court in any case to which it is a party," unquote. The decisions of the ICJ are binding and final on the states parties to the case and are not subject to appeal. And they quote the authority for saying so. The Charter itself says that, and the court statute say that. Another implication of a decision of the court is that that decision, because it is unappealable and because it's permanent, it forms part of the corpus of international law. decisions of the court graduate to that corpus. One legal foundation for the bindingness and enforceability of international judicial decision is the principle of pacta sunt servanda, which requires states to fulfill their international obligations in good faith. This principle is a fundamental principle of international law, and it applies to international judicial decisions, including those of the ICJ. States are obligated to comply with ICJ decisions in good faith, and failure to do so can have implications for their international reputation and legitimacy. Mechanisms for enforcing ICJ decisions. Enforcing ICJ's decision is a critical component of the effectiveness and legitimacy of the international legal system. That's the point I was making earlier. Enforcing ICJ decisions is a critical component of the effectiveness and legitimacy of the international legal system. However, as the ICJ has no direct means of enforcing its decision, there is a range of different mechanisms that can be used to promote compliance with ICJ decisions. And they are as follows. Firstly, the ICJ itself. One mechanism for enforcing ICJ decisions is through the ICJ itself. The ICJ has the power to issue provisional measures, as it has done here, which are binding on the parties and can help to ensure compliance with its decisions. Additionally, the ICJ can take measures to ensure the publication and dissemination of its decision, which can help to increase awareness of its ruling and promote compliance. B, the United Nations Security Council. A state which considers that the other side has failed to perform the obligations incumbent upon it under a judgment rendered by the court may bring the matter before the United Nations Security Council, which is empowered to recommend or decide upon measures to be taken to give effect to the judgment. The UNSC has the power, at the request of the injured state, to take special measures to enforce a judgment rendered by the ICJ under Article 94(2) of the Charter. The UN Security Council has the authority to enforce ICJ decisions, and it can take a range of measures to ensure compliance, including economic sanctions, travel restrictions, and the use of military force. The role of the UN Security Council in promoting enforcement. The Security Council has exercised its authority to enforce ICJ decisions in a number of cases, including the Corfu Channel case and the oil platform case. In these cases, the Security Council imposed economic sanctions on states in question, and it authorized the use of force to ensure compliance with the ICJ's ruling. However, since the 1900s, the record of compliance has generally been good. Let us see whether Venezuela wants to change this. For example, despite initial reservations, both Libya and Nigeria accepted the judgments of the court in favor of their opponents in the litigation in question. The political costs of non-compliance have to be taken into account by potentially recalcitrant states. Article 41 provides for non-military enforcement action, and Article 42 provides for military enforcement action. Article 41 reads, the Security Council, I quote, the Security Council may decide what measures not involving the use of armed forces are to be employed to give effects to its decisions, and it may call upon members of the United Nations to apply such measures. These may include complete or partial interruption of economic relations, and of rail, sea, air, postal, telegraphic, radio, and other means of communication, and the severance of diplomatic relations. Decisions of the Council taken under Article 41 and measures not involving the use of armed forces, such as to apply economic sanctions, are binding for the member states called upon. Article 42. Should the Security Council consider that measures provided for in Article 41 would be inadequate or have proved to be inadequate, it may take such actions by air, sea, or land forces as may be necessary to maintain or restore international peace and security. Such action may include demonstrations, blockade, and other operations by air, sea, or land forces of members of the United Nations, unquote. Article 42 must be read in conjunction with Article 43, which provides, all members of the United Nations undertake to make available to the Security Council on its call and in accordance with special agreements or agreements, armed forces, assistance, and facilities, including rites of passage, necessary for the purpose of maintaining international peace and security. The agreement or agreements shall be negotiated as soon as possible on the initiative of the Security Council. They shall be concluded between Security Council and members. So you have a wide range of measures that are available at the level of the ICJ and by extension at the level of the UN Security Council to enforce decisions of the ICJ. And as I said, the Western Hemisphere has always been a zone of peace. We have violent conflicts and confrontations at different poles of the globe. I don't think the international community, in these circumstances, having regard to the factual background of this case and the claim by Venezuela, will stand idly by and allow Venezuela to succeed. Because to do so has multiple implications and ramifications. It would render the ICJ a sterile, perfunctory institution, a toothless poodle. It would render the United Nations and its Security Council impotent and ineffective. The US has begun already to impose sanctions. Venezuela itself is imploding on this matter. The interim measures which we have received from the court have substantially shaken their position. The opposition leader in Venezuela called for the withdrawal of the referendum. I believe that the people of Venezuela rejected the referendum. Perhaps we may never know the accurate statistics in relation to the votes, but from all the images that is in the media, the international media, illustrate, in my view, very clearly that the Venezuelan people are not supportive of this referendum, and obviously the consequential actions. Our government continues to remain absolutely committed to explore, and we are exploring all avenues possible to protect the integrity of our territory, our sovereignty, the integrity of the proceedings still pending at the ICJ, and the protection of the public good in Guyana and keeping the population safe. We will not leave any stone unturned in this process. Fortunately, Guyanese have seen the great wisdom in standing united on this matter throughout our history. When the claim was first made, it was Premier Dr. Jagan was in office. By the time the Geneva Agreement was signed, it was Mr. Lyndon Fobb Sampson Burnham who executed the agreement. He was in office at that time. And Carlin Rodriguez, on behalf of the Donald Ramotar administration, wrote Secretary General Ban Ki-moon in 2014 to say that the process thus far employed has not yielded fruits, and that process, that engagement at the level of the UN continued under Carl Greenidge, under a different government. When government changed in 2020, our case was already filed, and throughout the process, though we were in the opposition, the leader of the opposition and the president met. Teams always met on this matter. If there is one thing that we agreed on, it was the importance of standing together on this matter. When we assumed office in 2020, we never even considered changing Carl Greenidge as the agent representing our case. We could have easily done that. But as a demonstration of a united front, Mr. Greenidge is always there. Him and I spoke at an event in New York last night on this same matter, again, showing a united front. And that is how we have to remain. Essequibo has always been ours, and it will always be ours. Thank you very much.
Thank you very much, Attorney General. Ladies and gentlemen, I'm sure that you have obligations elsewhere, but before you depart, the floor is open for questions. If I can be, yes, please, Mr. Fraser.
Gentlemen and ladies, wonderful presentations. All. Just two questions, Louis. First of all, does Guyana consider the holding of the referendum an infringement or violation of the interim measures that were ordered by the ICJ? And secondly, if it has Guyana made a complaint, given the procedure that you outlined, has Guyana made a complaint to the UN Security Council? Thank you.
Thank you, Mr. Fraser. In the ruling, the court considered the legal impact of the referendum in accordance with the law or laws of Venezuela and in accordance with Venezuelan constitution. In fact, prior to the court handing down its decision, the court asked Venezuela to put in an opinion on the legal effect of the referendum in Venezuelan law. And that's how Venezuela produced the court order to show that it had a court order legitimizing the process. And the court was careful. I suppose the court is guided by the fact and the legal reality that is dealing with a sovereign nation, and sovereign nations are empowered to consult their people on matters of national importance. I suppose we could have held a referendum ourselves and say, for example, that Orinoco belongs to Guyana. We didn't do that, and now we can't do that because both parties are enjoined from taking any steps that would render the case perilous or threaten the existing proceedings. So the court itself did not prohibit the referendum from taking place. So insofar as the referendum has taken place, I don't think we can complain about that. The court didn't prohibit that. That was a question that the court was directly asked, and it didn't grant that relief. And however, if there are steps that will be taken consequential upon the referendum, then different considerations will certainly follow and be relevant, because that is where the court order will be violated, because that is what is prohibited by the court. Of course, our government remains committed, as I said, to explore all the avenues. The Security Council, we are about to be elected actually as a permanent member of the Security Council. So there's another very important development that coincidentally now would have assumed greater importance than ever. So obviously we now have a greater presence at the UN when that materializes. But our permanent representatives at the UN are working assiduously in bringing the international community, the UN General Council, the Security Council, etc., up to date on the developments taking place. We are watching, and we will, at the appropriate time, invoke all the appropriate processes that will ensure that we are protected and that the international community does what it has to do in relation to Venezuela's continuous violation of the court order if they proceed in that direction.
Mr. Ram?
Excellent presentations indeed. Is the panel concerned that the ICJ has used on more than one occasion the word dispute rather than controversy, and particularly in the context of the soft language, administration and control, rather than sovereignty and territorial integrity?
Speaking for myself, of course, Ralph may have a different view, and Kim. Historically, we have avoided using the term dispute, but that was really intended at a political level, because it is felt that to use the term dispute is to confer some legitimacy on Venezuela's claim by recognizing it as a dispute. Instead, we have used the adjectival description of a controversy to describe the issue. But in a court of law, different considerations apply. Courts sit to resolve disputes. If, in fact, there's a whole body of law, if there is no dispute, the court will decline jurisdiction. The court doesn't sit to determine academic questions. There's a whole jurisprudential body of rules regarding that. So the court will describe it as a dispute, and they have done so. In terms of the fact that the court said, did not, as Justice Robinson said, he would have preferred the term sovereignty to be used instead of control. I am not too worried, Because while the court said what it said and used that terminology, the court repeatedly said that it is in no way making pronouncements on the merits. They are avoiding that absolutely at this stage. So I suppose if they were to use stronger language, it may be interpreted critically as projecting into the merits and going a little far at this preliminary interlocutory stage. And that's why I believe the court used the most neutral language, but said that Guyana's claim is a plausible one. Guyana has a prima facie case, and that the arbitral award of 1899 stands. And by that arbitral award, Guyana has that territory. All those things the court said too. So I believe that the court was very careful, circumspect, and didn't want to give Venezuela unnecessary ammunition. Venezuela has been attacking the court from the beginning of this process. So courts behave like that. We all know. They want to go, to me, they bend backwards to show their impartiality. And I believe that's what's playing out here. But I'm not too worried about that, because they have nothing to present. What are they going to bring? The same lawyer's memorandum? I don't, unless they come up with a new theory over the next 48 hours that we have not heard of yet. That remains their case. The other odd thing, as I have the mic quickly, is that we are lawyers, and they are saying that this arbitral award has been affected by fraud, and therefore, consequentially, it is a nullity. Well, we all know what is the impact of some process or document being a nullity. But they are not prepared to give back Orinoco. Because if the document is a nullity, Britain claimed, as Robert Schomburg had demarcated, our territory was all the way in Orinoco. So apparently it's only conveniently a nullity for Guyana. So what we got under the award becomes affected. This nullity is apparently half-baked. It only applies to Guyana, it doesn't apply to them. So they don't have to give back anything. But we must give back. You know. Every aspect of their case is nonsensical. Every aspect of the case.
Well, I agree with the Attorney General about the use. I was a bit disappointed in the use of the word dispute, but I don't think it has any legal bearing on what is playing out.
AG, I have a question. It may be a sensitive question. There is the view that the growing Venezuelan population in our country has the potential to create trouble that is relating to their claim to Essequibo. Are there any measures that the government is considering that is relevant to that?
So that question has been frequently raised in the public domain. First of all, when we did our examination of the numbers, what we found is that 80% of the persons who have come from Venezuela to Guyana are Guyanese, their children, and their spouses. And they have a legal right to be here. So that's the first thing. But then you still have a 20%, if our statistics are correct. Now, migrants are treated in a particular way, are to be treated in a particular way by international law now and by international convention. The lasting we want to do at this point in time, at this particular juncture, is to be in violation of international law and international convention obligations on any matter, more so one involving Venezuela. Secondly, it would be absolutely reckless to act in a manner in relation to Venezuelans here in Guyana that would create a platform for a desperate Maduro government. These people are not operating in normal circumstances and rationally. So if we have to be very careful on how you treat with these things. The other point that we have to make is that we have looked, the Venezuelans are here, and we have not seen, the local law enforcement agencies have not detected any evidence of any surreptitious, conspiratorial, organized action by the Venezuelan population here. In fact, the Venezuelan population have formed themselves into groups and have condemned Maduro and have expressed their support for the government. Lastly, like everyone else in the country, they have to obey the laws, and if the laws are violated by them, they will have to be charged and be part of the criminal legal process. Our troops are on the border, and I don't think that there is any movement anymore. I believe that, of people coming over, at least Venezuelans, and we hope that we continue to manage and monitor the situation that way. But the last thing I think we want to do now is to excite hostilities and encourage persons to be attacking Venezuelans. I don't think that will serve our national interest at all, not in these circumstances currently.
AG, my question follows up on Ronald's question. Have we considered direct migration in Essequibo from Venezuela, where Venezuelans become the new majority? And if they do that, and they decide that they would like to have a declaration of independence as a form of self-determination, have we considered the consequences of that in light of the fact that the ICJ has ruled that that a declaration of independence is not against international law?
Well, Venezuelans coming over into our territory, which will remain our territory, can only become citizens of Guyana by a process controlled by the state and by the government of Guyana. So I don't know how, at some point in time, we will have to regulate, and right now, let me just digress to say that the government is working on a migration policy right now, because we expect that with our economic fortunes getting better, we are going to have a migration problem in Guyana. And we have to protect our local population and our local industry, etc. We are working on that. We recognize that. That's an international reality where people migrate to greener pastures. So as a government, we have to tackle that. And more peculiarly, we have to now focus on a Venezuela intrusion, for want of a better word. But as I said, they can only become citizens of Guyana by a process outlined in the Constitution and in the Immigration Act, the Citizenship Act. And that process is controlled by the state and the state apparatus. So I can't imagine that it will happen just like that by they just coming over and settling and becoming a majority. That it can't happen. I mean, is that a real possibility? Is that a real possibility?
I don't want to deal with issues outside of this, but we have living examples of, the settler movements and that sort of thing. And we're hearing a lot about it now, particularly in the West Bank and that sort of thing. I think that what my colleague is trying to identify is that the law is all great, but on the ground, if 500,000 Venezuelans come over, howsoever they come, we could possibly have a practical problem. And I mean, the international law and its force and authority, all of that is great. But there are multiple examples in the world now in where it is very clearly being demonstrated that might is right. The West Bank, it's over 1 million settlers who live in superior circumstances to the supposedly lawful inhabitants of the land. And I don't want to perhaps say things that my colleague did not want to say, but I sense somewhere in there. I really think her concerns must be taken seriously.
So, it is a situation that we have to make provisions for. At one time, it was felt that we would have been overwhelmed by Brazilians. I know you frequent many of the establishments that were popping up at the time, but it didn't materialize into any great problem. Not that I'm saying that it will not happen, but it is something that we are consciously monitoring, particularly because Venezuela has different importance. Venezuelans have different importance. So we have to hurriedly deal with it, because I agree with you. They are all over the place on the East Bank, all the villages on the East Coast. I do a lot of political work on the East Coast, and the numbers are large on the East Coast and so on. So yes, it's a problem we'll have to look at.
The AG might not be willing to say this, but being a part of the government, but I'm aware that efforts are made to disperse the migrants from Venezuela, to locate them in different parts of the country so that they do not congregate. I'm not saying that this is an official policy of the government. I'm just aware that efforts are being made to ensure that they don't congregate in the Essequibo region.
Good evening, members of the panel, and thank you for your presentations. AG, my question centers around your comment that the Venezuelans have not put in a counter memorial, and I'm really after where we are in the ICJ case, which is to say, what can we expect next? Since they haven't filed, is there any timeline given for them to file, and when can we actually expect that the dispute would end?
So, at the level of the ICJ, the timelines are, as you would expect, they are long. So they are at an average of a 6 months period to do, and then you're entitled to an extension of 3 months what our experience has been so far, that Venezuela exhausts every possible opportunity to delay the matter. So in their jurisdictional objection, they first said that they will not put anything in, and then at the last stage, they put in something, the court entertained it, and that caused a shift in time frame. We are about to expire, I believe, their time for entering the memorial, the counter memorial. I think it would expire, I believe, December. But more likely than not, they will ask for an extension. And the court's policy is to grant it rather than shut people out. And I suppose, so they will extend it again. So the bottom line is that the case at the ICJ will not be determined till after 2006, 2026, thereabouts. So what happens in the interregnum is a matter of great importance. And that's why the referendum, having been rendered, in my respectful view, as perfunctory by the ruling of the ICJ, and in any event, the physical referendum has taken place and it has been concluded, but that will not wish this matter away. We have to continue to work every day at all levels to ensure that the court order is observed and obeyed, because it's a status quo order until the court determines the matter. So we have to be vigilant and every day continue to work internationally in getting more and more support and observe what is going on, so that we will have to activate different processes if the situation, if the crescendo increases on that side.
Ladies and gentlemen, having regard to you've all been a really wonderful audience being on time. I'd like to respect that by also drawing the proceedings to an end in a timely manner. And so I'd like to invite our first Vice President, Ms. Pauline Chase, to move the vote of thanks. Thank you.
Thank you, Mr. President and Chairperson, for the proceedings this afternoon. I have the pleasure, well, afternoon into evening, I have the pleasure of bringing us to a close this evening. In doing so, please permit me to thank the panel this afternoon into evening, Dr. 𝘰𝘰𝘃𝑠𝑗𝑺 Thomas, Mr. Ramkaran, and the Honorable Attorney General. They are, as you can see, persons of exquisite caliber, and they have so readily shared their time and their knowledge with us. Dr. Thomas, in her usual style of frankness and being down to earth and very succinct, really wrapped up what Venezuela's arguments were. Mr. Ramkaran, Senior Counsel, who I think can be best described as a walking history book. And he isn't here this afternoon, he isn't here at the moment, but Kamal, I hope a book is actually in the works where he shares his knowledge and reduces it to writing for posterity. And if it's not, is he coming in now? Yes. I was just saying, Mr. Ramkaran, Senior Counselor. I hope you do have a book in the works to share your knowledge on this process with us and the activities behind the scenes. I think it would be really important to do so. And if you don't have it in the works, I encourage you to do so. And of course, the Honorable Attorney General for taking us behind the scenes in the legal arguments and what is transpiring at the ICJ. I also wish to thank the Honorable Attorney General and his chambers for collaborating with us on this symposium this evening. Ms. Deborah Kumar, who's the Deputy Solicitor General, worked very closely with us, and thank you, Ms. Kumar. Thank you also to the Arthur Chung Convention Center staff for so readily facilitating us on short notice and putting everything together. Thank you. And last but certainly not least, thank you to all of you for attending this evening. Your presence here shows how important this issue is and how important it is to you and to us as a people. So thank you all so very much for spending some time with us this evening. We do have some snacks and some refreshments downstairs, just as you exit down the stairs to your left, I believe it is. Please do join us. The panelists will still be present in case you didn't get to ask any questions and you wish to interact with them or with each other. Thank you all. Please have a good night and get home safely.
𝘰𝘰𝘯𝘵 belongs to Guyana. 𝘰𝘰𝘯𝘵 belongs to Guyana. 𝘰𝘰𝘮𝘋𝘴𝘪𝘐𝑵 belongs to Guyana.